last thing I've ever done want to do in my life.
Trust me, can truly understand that.
Playing with my kid. Next thing you know, this.
Oh, me or you? This is mine.
Yes, you.
All right. Hey, sir. Let me just kind of stand like that. So I just want to. You live right over here?
Yes, ma'am.
Okay. Do you have any bruises or any marks on you or anything? Do you need the squad to check you out?
No,
I just heard you said hit you.
he struck me a few times. It's
okay, well
but I'm
let
fine.
him look at you.
Okay.
Do you have where were you struck
Face.
at? Okay, that's fine. Just let me. Like I said, we don't want to miss anything, you know. Let's do that. This is you right here, this house?
The house straight across from the gentleman right there in 230.
Okay.
230 still drive. And then that's my father. He was with me with this whole thing.
Okay. Jeff. Good. All right. We are going to take your clothes, but we're going to let you go home and get it changed. That's why I was trying to make sure how close it was.
Absolutely.
Yep.
All right. Happy New Year. Our first inaugural session here at the Law&Crime Network. I'm so happy to be here. We got some great guests. What you just saw there is Travis McMichael right after the shooting of Ahmaud Arbery. As you guys know, this is a very controversial case. They have been arrested. There were 3 people involved, the father, the son, as well as a third individual. Ahmaud unfortunately expired during this incident. This was one of those cases in which they're claiming that he was burglarizing something. They gave chase in a vehicle. They got out of the vehicle, Travis with a shotgun. An altercation occurred and shots were fired and the victim was killed. The question in this particular case, and I use that word victim because it's going to be very important to the discussion we're going to have today, is whether or not he is a victim or whether this was an action of self-defense. The defense attorneys have filed some very aggressive motions. Having reviewed this case and reviewing the motions filed, I asked one of our the executive producers, to whether or not these were private lawyers, what's their nature, the circumstances of the lawyers, because I could tell by the paperwork it is going to be an intensely fought case. Some of the motions that are filed that you should know about is they do not want Ahmaud being referred to as a victim in the case. They're also asking the court to limit the number of photographs that are going to be admitted before the jury and to have a non-related, non-family related person make the identification in court of those photographs in order, they say, to avoid undue prejudice. And they also want to forbid spectators from coming into court with either masks or T-shirts or any other identification or insignia that deals with Black Lives Matter or I Can't Breathe or any other similar slogans, because they believe that that would be prejudicial. And lastly, they're asking prosecutors to turn over all records of Ahmaud Arbery with respect to any potential, we're not saying that they're out there, criminal records, disciplinary, mental health, and or addiction records. So we got some great guests here with us today to help us navigate this kind of stuff. One is Bob Hille, focuses his practice in the areas of insurance defense and criminal care, healthcare law, state and federal white crime collar investigations, including those allegations and charges for healthcare fraud and abuse. He is a certified Supreme Court trial attorney in the civil world. That is a very high distinction, I can tell you that, in the state of New Jersey. He is the past president of the New Jersey State Bar Association and a law and crime analyst. And of course, we have Bernarda Villalona with us, a senior trial counselor at the Joey Jackson Law Firm. Joey's a good friend of mine, excellent attorney, excellent firm. Bernarda's a great addition to that. A former Philly and Brooklyn Kings County District Attorney, over 100 trials, including numerous homicide cases as the prosecutor and senior homicide ADA, and a TV legal analyst, Bob being a law and crime legal analyst as well. Guys, welcome to the show and Happy New Year.
Happy New Year, Bob. It's great to be back.
Yeah, it's great to be back with you guys. So let's go to this first one, that the defense is arguing that Ahmaud should not be referred to as a victim in the case. And they're essentially saying, and this is a quote, that use of terms such as the victim allows the focus to shift to the accused rather than remain on proof of every element of the crime charged. Bernarda, I'm going to start with you, having been a former homicide prosecutor. I kind of understand that argument, but I just wanted to know what your opinion is about the fact that when you refer to somebody as victim, you're essentially saying to them, it is a proven point that this person was the person that was the subject of a crime, and yet you have a self-defense case on the other side of that where they're saying, no, he's not a victim of a crime. We were the victims of a crime, and we responded by self-defense. You're seeing this don't refer to the victim as victim arguments more and more in court. We used to say it all the time, but it's become a hot topic. What do you think?
So, Bob, as you know, as a trial attorney, you're being very strategic as to every word that you use and also every label that you decide to use. Obviously, in every case, the defendant is entitled to a fair trial. So in order for there to be a fair trial in this case, I believe it is right for Ahmaud Arbery to be referred to not as the victim, but more of let's refer to him as the deceased. Again, we're talking about a person that was killed. We are talking about the defense saying that they killed Ahmaud Arbery in self-defense. So that being the case, the labelization of the term victim is hence already making the decision for the jury when the jury is supposed to be the fact finder and to determine who was the actual victim in this case. And again, you know, I'm putting emotions aside when I say this because I truly believe Ahmaud Arbery was the victim in this case. However, in a court of law, he should be referred to as a deceased.
Okay, let's look at a clip of Wanda Cooper Jones, who's the mother of Ahmaud, speaking at a bail hearing for the McMichaels.
Someone contacted my attorney on the behalf of Glenn County this past spring during the course of the GBI's secondary investigation. They discovered what they believe to be one of Ahmaud's bone fragments near where he was murdered in Satilla Shores. They wanted to know what we wanted to do with those pieces of my son that they were still discovering in the streets. I have sat here and I've listened to the attorneys for both Travis and Gregory McMichael. They tried to explain that their clients believed that my son was a trespasser. On that bright Sunday afternoon, as he ran down the streets, he was somehow engaged in a criminal enterprise. Their defense is summed up in an idea of grabbing their guns, chasing, boxing my son in with the vehicles, pursuing him, and eventually shooting him to death, ripping his body into pieces. And that was the right thing to do. That, if given the opportunity, both men would do the same thing again. These men are proud of what they've done. And they want to go home because in their selfish minds, they think that they're the good guys. And I and my family is left literally to pick up the pieces.
That's the mother giving an impassioned speech during the bail hearing, of which bail was denied. Bob, I got a double dipper question for you. With respect to the motions that have been filed, one of them says that they do not want a family-related member making the identification in court, because obviously that can have a huge impact on a jury when somebody like mom gets up there and gives testimony. And the second part is they want to forbid spectators from wearing masks and things that either have Black Lives Matter or I Can't Breathe. Some would argue that is a First Amendment violation, but speak to us a little bit in that respect with regard to where the First Amendment begins and ends when it comes to having a fair proceeding in a trial with a defendant in a courtroom.
Well, what's interesting is with a criminal trial, of course, the Constitution under the Sixth Amendment says it has to be public and also has to have an impartial jury. The Fifth Amendment says it has to be governed by due process. So you want fairness in the result, you want integrity in the process. So the court has to ensure that that happens. political expression has a role in society, it's recognized, but where it treads on the rights of an individual to assert other constitutional rights, like you have here in a criminal case, the courts have been supported in their limitations on that right. You've seen cases where they've done it outside, where they have had made expressions, First Amendment expressions, but in the courtroom, the judge's responsibility is to control that proceeding and make sure it's fair and consistent with the defendant's constitutional rights.
Yeah, so just to give you a quote, the defense lawyer said, once inside the courthouse, they're not arguing outside the courthouse, but once inside the courthouse, Bob, to your point, the sanctity of the defendant's right to a fair trial and an impartial jury trumps the First Amendment. What are your thoughts about forbidding Black Lives Matter paraphernalia or anything of the sort in the courtroom?
Well, again, how does that help the jury decide the case fairly, which is the jury's responsibility? How does that preserve the defendant's rights? And you got to compare that to how does it deprive or deny those spectators their rights? Well, their rights to express are not really harmed by being forced to have those where they don't impact any other constitutional rights. And I think that goes to my point here. Outside, public places is fair game. The courtroom is a public place, but it's designed to make sure that the process reaches a result and that jury reaches a result that is impartial and due process requires is fair.
Okay, Bernarda, listen, they're trying to limit down the identification to a single photo with a non-family related member. Thoughts about that, as well as what do you think, based on your experience as a homicide prosecutor, the defense asking for all these records about criminal history, mental health issues, disciplinary history, whether or not that's a fair request, and your thoughts as to whether it be produced?
So that's a lot to unload, Bob. So let me just start off. When we're talking about, let me just go back. In terms of what people wear in the courtroom, again, I think it's the First Amendment that actually carries and will carry the day. The only prejudice that will take place, and I can see a judge because it's been done in New York, is that people, spectators in the courtroom cannot have photographs on their shirts that depict the deceased. So that is not allowed in New York just because they found that it does impact the fairness of a jury. Now, in terms of the defense attorneys here requesting the background for Ahmaud Arbery, it's not relevant. And this is why it's not relevant. What is relevant to determine if this was an act of self-defense, of justification, it's what the McMichaels knew at the time that they decided to take away the life of Ahmaud Arbery, not his past. They have to decide, the jury, based on everything that was put in front of them, based on what was in the mind of the McMichaels at the point when Travis McMichael decided that he wanted to take a firearm and take the life of Ahmaud Arbery. Not his background, not any mental status, not any negativity of his past. It's what occurred on that day at that moment when he decided to take life. Now, in terms of limiting who can identify Ahmaud Arbery in the photographs, look, a prosecutor is allowed and has to prove their case beyond a reasonable doubt. So as long as they're acting in all fairness, then that should not be a problem about what pictures they put before the jury to identify Ahmaud Arbery or what witness to identify Ahmaud Arbery. Obviously, a witness has to testify that the person that is deceased is Ahmaud Arbery, and that's why that person is allowed. They are not limited to who gets to be that person, and the defense does not have any right to determine who that person gets to be.
Yeah, well, interesting. Listen, defense doing their job. They're filing aggressive motions to both of your points, whether they succeed or not. We will see, but they're preserving things for on appeal. And listen, guys, we're going to take a quick break here, but Kyle Rittenhouse, as I've always said to you guys, not just in 2020, in 2021, and I expect forward, is back in the news again with a legal permutation. We'll be right back after the break. Stay with us.
Your Honor, I believe the evidence in this preliminary hearing has established probable cause that the defendant committed a felony on August 25th, 2020. The evidence indicates that the defendant shot and killed two individuals and shot and wounded another. which forms the basis for any number of felonies under our laws. All this court needs to find is that a felony was committed and probably committed by the defendant, and I believe this evidence supports that. With regard to the defense claim as to self-defense, that does not defeat probable cause at this stage of the proceeding. That would be an issue for trial. So I would ask that the court bind the defendant over. Thank you.
Okay, so there is the prosecutor giving us a description of what they say is the probable cause to keep remanded in the jail. There were a number of injured victims. This involves Kyle Rittenhouse, who was 17 years at the time. There was a protest, a rally, a quote unquote melee that broke out over the police shooting of Jacob Blake. You may remember back in the day. Well, here's the development. A notice of claim was filed by for two of the victims of that shooting. And essentially, they're saying that the Kenosha Police Department, as well as the county police agencies, including the sheriff's officers, were negligent in the manner in which they were maintaining safety, health, and security at that location. The lawsuit is claiming $10 million for each of the people that filed it. And there will be a response, obviously, to that notice of claim at some point in time. Let me bring back my guests, Bernarda Villalona, as well as Bob Hille are with us today. Bob, I want to go to you first as a civil litigator. Talk to us about this idea that they're saying there was negligence in the manner in which the police handled this, and that negligence, how does a civil lawyer go about proving that negligence was the proximate cause of the injuries to the individuals, and what kind of lawsuit do you think this is, good one or a bad one?
Well, it's certainly going to be an interesting one. I don't know yet whether it'll be good or bad. That's going to depend on what kind of evidence they marshal. But obviously, they have to establish first that the officers for the city and county government had an obligation to do something in terms of checking the activities or the person of Kyle Rittenhouse, and that had they done that, that would have prevented the injury and the deaths of these individuals. So that'll be the center of this whole thing. It's difficult too in a place where the gun laws are somewhat liberal as well, because we all remember in August of 2020 when these scenes of Kyle Rittenhouse walking along and then being people trying to stop him. Some of them were the victims here, or alleged victims. So that complicates things in terms of what could the police do if Rittenhouse, under those laws, had the right to walk on that street fully armed. And I think that that's going to be an interesting issue that's going to underscore a number of issues, not the least of which is going to be laws under the Second Amendment.
Yeah, Bernarda, to that point, we have the lackadaisical gun rules, we have that. But also in a negligence case, you have to say there was a breach of a duty of care that was a proximate cause of the injuries. And, you know, in a situation like this where riotous activity is occurring and there's lots of people carrying weapons that are out there, you were a former prosecutor, you worked very closely with police officers. What do you think of the value of the suit and also the immunities that may be out there in that state that protect all but unreasonable conduct of police officers?
Yeah. So it's going to be a huge problem here, Bob, for there to be any success in prevailing in this type of suit, even if it gets that far. So one of the huge problems that they may face is that, one, we know that there is video out there with Kyle Rittenhouse walking along the street, walking in the streets with this big firearm, a rifle that almost looks like half his size. And that we know that there was at one point that there was testimony, or I guess video, of an officer actually handing water bottle out to Kyle Rittenhouse. So that piece of footage is going to work against these people here, against the police officers, because one, you know that Kyle Rittenhouse, by looking at him, you can definitely tell that even though the gun laws are lackadaisical in that area, still you're not allowed to carry a firearm if you're under the age of 18. And here we have Kyle, a juvenile, carrying this large firearm. And aside from that, we have knowledge that these officers were making contact with him and even offered him water as he's walking past. So any officer has a duty to take care of the citizens. They have a duty to protect and serve, and they weren't doing that on that day.
point, and I understand it completely. It's not in hindsight what the officers knew. It's what's unfolding at the time the incident happened. I mean, they're not checking IDs and saying, how old are you? Do you have the right to carry a gun or not carry a gun? So a lot of those cases, to your point, I think before, is that it's going to really determine whether or not they breached a duty of care, if there was something they did in their tactics. And, it becomes very difficult. On one hand, people want to have their First Amendment right to protest. Those protests sometimes turn violent. And then when the cops, if the cops interceded ahead of time, then people are agitated that their First Amendment rights are violated. And by the time violence starts, sometimes it can be completely out of control at that point in time. I've been in this situation as a chief law enforcement officer. It is a sticky situation for police officers. Damned if you do, damned if you don't. You limit the protest, you're going to be sued for civil rights violations. If a riot breaks out, now you're in a situation in which you got to do the best job you can under the unfolding circumstances. And Bob, to my point, you tell me if I'm wrong, they don't expect perfection. They don't expect it to even be good. It was what was happening at the time and whether the officers' actions were reasonable, not based on what we now know about the case, but as it was unfolding at the time.
No, I think that's exactly right, to get around the immunity that the government entity usually has, or police usually have. Bernarda made a great point, is that if he's under the age, that he's entitled to be there in the street carrying that weapon, and the officer interacted under circumstances where there was a public disruption and a riot going on, then the question becomes, should that officer have said to him, hey, wait a minute, who are you? What's your identification? And done some checking on that. So that could be an issue in this case to get around that.
Yeah, I think officers are going to also have a defense to that it's not our job when people are allowed to carry guns to be checking IDs when there's riots breaking out, that there's actual safety issues occurring at that time, not technical issues with regard to IDs. Guys, great commentary. We'll see where that goes. Got to switch gears a little bit. I know you guys have to be really disappointed in hearing this, and I expect we're going to hear a lot more weirdness as it relates to the COVID-19 vaccinations. We have a pharmacist who is now charged with having removed from the freezer 500 doses of the COVID-19 vaccine. And the Grafton Police Department is indicating that they were called to the Advocate Aurora Health Hospital on a report of a former employee who was intentionally removing vaccine from the refrigeration system and leaving doses out overnight in order to render them useless. We're talking about $8,000 to $11,000 worth of product there. There is supposedly a confession by the pharmacist that he did this on purpose, that it wasn't an accident, and that he knew the vaccine would be spoiled. And that actually, I don't know how this occurred, but some people, 57, got doses of this now ineffective vaccine. Bernarda, pretty serious allegation. And having been a former law enforcement officer and prosecutor like yourself, it's not just morally reprehensible, given the paucity of these vaccines. The possibility that somebody believes they're vaccinated and they're not, who could get sick. The possibility that somebody didn't get that vaccine that could have been saved. Do you see some serious charges being filed? Like right now, I can tell you we have first-degree reckless endangerment. We have adulterating of a prescription medication and damage to property. Bernarda, do you think that prosecutors are going to try to link this to somebody being ill and potentially upgrade those charges?
I definitely see that happening. We're going to have to just wait and see, because regardless if they try to upgrade those charges, it's going to take a long time for them to figure out whether there is a connection between thinking that they got the vaccine and then later on getting sick, especially since now they've already caught what the issue is. They've already caught and found out that these people, and it's 57 people that were actually given this COVID medication, thought that they were getting this COVID medication, and it didn't take place. However, the charge that he's facing now, he is facing up to a $25,000 fine, but also he is facing on this Class F felony up to 12 and a half years of incarceration. But this is morally just wrong. It's wrong on so many levels, and very disappointing that a pharmacist, a person that has sworn by getting his license that he is to take care of people, and this is what he's doing.
Yeah, and I think Bernarda, myself, and Bob, all having been in that prosecutor world at some point in our careers, can say that one of the things prosecutors look at is deterrence. And because prosecutors know that there's going to be a lot of game playing, black market stuff, people trying to pay for it, I would imagine prosecutors are going to look at this case as making a very strong message that if you're involved in any of that, there are going to be significant penalties. Guys, Ghislaine Maxwell is back in the news again. We're going to cover that and the new developments with respect to that on the other end of the break. Stay with us.
I'd like to take a moment again to speak directly to the victims. There never was, nor shall there be, an excuse for the criminal behavior you were subjected to. We know that your quest for justice has been met with great disappointment and that reliving these events is traumatic. When we met you, we told you that in the eyes of the FBI, you come first. I would like to thank you for the trust you place in our investigative teams as we work to hold the adult perpetrators accountable. For the many victims of other adult perpetrators who may be listening or get word of today's announcement, the example set by the women involved in this investigation has been a powerful one. They persevered against the rich and the connected, and they did so without a badge, a gun, or a subpoena, and they stood together. I have no doubt the bravery exhibited by the women in this investigation has empowered others to speak up about the crimes that they have been subjected to. If you are listening today and are the victim of child sex trafficking, please call 1-800-CALL-FBI or contact us online at tips.fbi.gov.
Okay, there's the FBI talking about the victims there and how powerful they were to come forward with the case. Now, as you guys know, Ghislaine Maxwell last week filed yet another failed bail motion, and apparently sparks were flying at that point in time. And Maxwell's lawyer, Laura Menninger, wrote the following to the court. It's a little long, but it's really interesting because maybe this gives us a snapshot into what the defense may be at trial. And it says, the fact that the victim seeks money from the estate, they're referring to of Jeffrey Epstein, and from Ms. Maxwell in millions of dollars at the same time she is a government witness is in an ongoing criminal trial on the same topics is reason enough to suspect that her new asserted memories of abuse without corroboration are not based on the truth or desire for justice so much as her desire for cash. The motive for fabrication could not be clearer. That lawyer for Maxwell is also asking that there be a disclosure of the amount of money that that victim had already settled a case with the Epstein folks. There's a fund that's set up for that. They want to know how much money she got. There's going to be a debate. The judge so far has indicated that they're not going to allow that to happen. We'll talk to our guests as what they think about the judge's decision on that. I should say that the victim's attorney responded to Maxwell's attorney by saying this is nothing more than vicious victim blaming. Bernarda, what do you think about? Is this a snapshot into what the defense is going to be? It's all a money grab. And secondarily, what do you think about disclosing the settlement that the victim made with the Epstein people? Is that relevant perhaps to the credibility or goes towards that theory that Maxwell's attorneys are asserting it's about the money?
Well, the media is being used in the favor of the defense. Obviously, the defense attorneys in this case, that even though the judge may not rule in their favor in getting what they want, they're still putting it out there where the potential jury pool is listening to this information. So they're working it from both angles, from inside the courtroom as well as outside the courtroom. Now, when it comes to disclosing the amount of this settlement, one, that settlement was with Jeffrey Epstein. It had nothing to do with Ghislaine Maxwell. However, I will say this, in any trial, any witness that testifies, whether they're a witness, a victim, or a complainant, their credibility is always at issue. And the jury has to determine their credibility. In order to determine the credibility of any witness, it will be crucial, especially a witness like this, for the jury to know whether she has a motive to lie or benefit to gain by making these allegations. And a huge benefit is always money. And that is exactly how the defense is going to tackle this trial. And I think for the jury, it's going to be important for them to know that, yes, there was a settlement. Now, the actual amount, I don't think is relevant for the jury to know. So the jury can the judge can actually just say, sure, you can question her and say, did you settle, got a certain amount of money based on a civil suit? And that's it. Leave it at that and keep on moving. Let's not forget what that jury is selected for. And that's for the actions that Ghislaine Maxwell took in using this young girl for the benefit of Jeffrey Epstein.
Yeah, fair point, Bernarda. But Bob, let me ask you. I would be fashioning the argument if I were a defense attorney, and I would expect it coming at me when I was a prosecutor, that there's money and then there's money, okay? She was able to raise $22+ million in this bail application and has substantial assets. And here's the argument I would make as a defense attorney. It's not like she can get $10 or $20. She has the opportunity of getting millions and millions and millions of dollars, and that's millions and millions of dollars of a reason why she would be incentivized to testify favorably for the government. I'm just saying, I mean, the significance of the quantity of money and what she's already received, that would be my argument I would make as a defense lawyer. What do you think about that argument? I'm not saying it'll win, but what do you think of it?
Well, no, I mean, I think that's going to be an extremely effective argument. As Bernarda just said, they're playing the media on for the jury pool, but they're also giving insight into their attack on credibility, and motivation is going to be part of that attack in terms of, is it so great to the extent of that it's going to invade not only accuracy but truth, and of course that none of this is true. That's what the defense wants the jury to conclude. So, to your points, money grab, yeah, that's what this is about, and not only a money grab, but a money grab from a big bank, Ms. Maxwell, because she has assets and they're looking to take a lot of assets from her. So as you just pointed out, it's not just a question of saying, well, this person, these witnesses, because now I think two, have an interest in succeeding with this prosecution in terms of their civil cases. But they stand so much to gain in their civil cases that there's a reason for them not just to bend the truth, but to fabricate the truth.
Okay, guys, excellent analysis. Well, we're back to Lisa Montgomery. As you all know, there was a reinstitution of federal executions after years of a moratorium on them, and she was scheduled to be executed, but it got delayed because her lawyers got COVID-19. Last week we covered this. The judge had suspended the reinstitution of a new date of January 12th for them to be for her to be executed, indicating that it was improper for the Department of Justice to reschedule the date while this case was stayed at least until January 1st, while the lawyers had an opportunity to not only get healthy, but to file a petition for clemency with respect to their case. They're saying she's had significant mental health issues and abuse. You guys may remember this case. It's about as bad as it gets. She abducted a woman and literally with a kitchen knife cut her 8, I believe it was, month-old baby from her and kidnapped the baby. It was just really a tremendously horrible crime. So a panel in the appellate division has indicated, no, the district court judge was wrong, and they ruled that under his order, the BOP could not be stopped from rescheduling the execution. So it is very possible this execution may occur in the next period of time prior to Joe Biden taking office. And the reason that is extraordinarily important is Biden has already made it clear that on day one, he is going to stop federal executions. So, Bernarda, when you go to this, I've had a big problem with this as a person who has tried death penalty cases and handled them as a prosecutor. I am not an advocate of it any longer, only because I've seen the system sometimes being so wildly inconsistent. And here, by my calculations, 8 days could be the difference between whether somebody is executed or not. Now, I understand that our audience is going to say she should burn in hell for everything she did. There's going to be a segment of the population that says that. And I understand that sentiment. What I don't like is the arbitrariness of this. The lawyers argued that the clemency petition is a vital, important part of the criminal justice process, and they should have the ability to file it and potentially file appeals of something of some nature, which would push it over that arbitrary line of January 20th. It's literally the difference between life or death. What do you think?
And so I agree with you, Bob. I'm not going to take a stance whether I'm pro or against the death penalty, but what I am pro of is transparency. I'm pro of transparency and fairness. So I just find I have issue with how everything is transpiring because obviously a couple days will make a huge difference for the life of this woman. Fine, we know that a jury convicted her. The jury convicted her for killing a young woman, and after killing her, actually cutting her baby out of her stomach and taking that child for her own. And for that action, the jury convicted her and sentenced her to death. However, what I think needs to happen, and again, I always state this, that in order for there to be any trust in the criminal justice system, there has to be transparency and there has to be good faith. And I find that the actions that are taking place now are getting more political as opposed to going through the normal reels of justice. And that's a problem for me.
You know, Bob, to Bernarda's point about political, one of the reasons why I handled these cases, but it was against us, I literally handled a case where there was a white defendant who was charged with a death penalty offense. It became very clear during the course of, it was like a year-long trial. The victim's family even wanted to take the death penalty off the table. They couldn't take it anymore. There were so many issues that occurred during the case. We were absolutely convinced the Supreme Court would never uphold the death penalty. We were absolutely convinced. Jersey was very tough, as you know, never executed anybody with all the death penalty convictions since it was reinstituted. They found every way, shape, or form not to do that. And when we went to get it removed, we had to get permission from our higher ups, and they wouldn't give it to us. And the basis they wouldn't give it to us was because of the proportionality argument, as they call it, where they said this is a white defendant charged with the death penalty, and if you remove it, it will skew the facts in favor of the argument made by minority communities that more minorities get executed and get the death penalty than white people do. And I was like, that's just as bad a reason to make a decision one way or the other. Race shouldn't come into play with it all. Statistical analysis should, just if it applies more to one than the other. But it was at that point I just shook my head and said, the victim's family wants it, the court wants it, the defense certainly wants it, the prosecution agrees to it, but we had to go forward with that case anyway. I just find this to be extremely arbitrary.
Well, you know, that's the problem. Justice should be blind, not turn a blind eye. So you always have, in terms of, especially with penalty issues and the death penalty specifically, you have the political versus the legal. Now, if you're looking at it strictly from a matter of law, if the death penalty was lawfully created, it was lawfully enforced as a legitimate form of punishment, and there's a process developed for imposing that as well as challenging that, then what's important from the justice standpoint is, was there a right in this case to file that petition for clemency, and was the process to do that fair? It shouldn't matter who's going to be in office in terms of whether or not they're going to enforce that sentence with respect to that outcome in that case, if you're looking at it strictly from the legal standpoint. Obviously, from the defendant's standpoint, they don't want to be executed. And so, you know, they're going to try and get that delay, hoping that the death penalty won't be imposed. Very similar to Charles Manson situation, where California knocked it out.
Tough decisions, guys. Very good analysis. Tamir Rice, 12-year-old boy in Ohio, outside in a park outside a recreation center, that was shot and killed by police. You may remember, because he had a toy pistol. That's back in the news. We'll have more on it when we come right back. All right, the Department of Justice in the Tamir Rice case has made a major announcement. They are not filing any charges in that case. They were investigating that case for civil rights violations. This is a common cadence that goes on with cases like this. State prosecutors presented this to the grand jury in 2015, and there was no indictment. But the feds usually pick up these cases if they think it's warranted, to see if somebody's civil rights were violated, which could be a criminal charge as well. Well, the DOJ has declined to do that. We're going back to 2014 in Ohio Park, where the young man, 12 years old, was there. A 911 call came in that indicated somebody was brandishing a gun in the park, and it was probably a juvenile. But the dispatcher never gave that particular identification to the officers on the scene. An officer in training went to the scene, Timothy Lohman, and within 2 seconds of getting out of his car, fired shots, killing the boy. Tragic, tragic case. The boy had a toy pistol in his hand. The police officers indicating that he believed he was going to his waistband to pull that weapon. And as a result of that, they fired shots because they believed they were in danger. The DOJ said the following, that they couldn't prove the officers' actions were, quote, unreasonable or willful, and that a police officer is allowed to use deadly force when they reasonably believe a suspect possesses an imminent threat of serious bodily injury to the officers. The DOJ went on to say they would have to prove two things in order to have a successful civil rights claim. The first thing would be that Tamir was not reaching for the pistol, and in addition to, they would have to prove that the officer did not perceive he was reaching for the gun. I should say that this case settled for $6 million in 2016 with the family of the young man. Bob, we were talking about this offline a little bit. Prosecutors need to go in there. We had a famous case in Jersey where this happened, where the state grand jury did not indict on a cop-related killing of an individual that they believed killed the cop. Turns out the person didn't, yet they were charged with civil rights violations and got significant federal prison sentences. What do you think about the DOJ, the Department of Justice's resolution of this case with regard to what they said is the reasons why they will not, in this case, pursue civil rights violations?
Well, I mean, you know, it's one thing between getting an indictment and the lower standard for that and having to win a trial. And as you pointed out during the break, the ethical obligations that prosecutors are under. But here you had a couple of things working against or in support, at least, of the decision. Number one, a grand jury said no, and they looked at it from a lower standard on similar charges, but on the related same conduct. Two branches of the Department of Justice looked at it, the Civil Rights Division and the U.S. Attorney's Office in the Northern District of Ohio. So they made a joint decision on that. They looked at video evidence of the shooting, the officer's statements, witness interviews, and they looked at experts' statements. And, you know, they concluded, as you said before, that they'd have to prove, and they didn't believe they could, that Tamir was not reaching for his gun and that Lohman did not think that Tamir was reaching for his gun. And that belief was actually consistent with numerous statements that the officer had made. So for those reasons, they felt justified in not taking the case to prosecution.
Yeah, Bernarda, we were talking about this offline too. You know, prosecutors' ethical responsibilities in presenting a case to a grand jury is not just establishing that lower level necessary to get an indictment, but the ethical responsibility that they believe they can prove a case beyond a reasonable doubt in the end analysis. And also concerns of prosecutors that if they just indict a case simply because that's what the court of public opinion wants, things could get a lot worse if you wind up at trial and you can't seek a conviction. So as a former homicide prosecutor, what do you think about the analysis that they came up with regard to the elements that they say they need to prove and their feeling that they did not have sufficient proof to move forward with it?
So, Bob, in this case, I think the analysis was right on point. While this is a sad case, very sad and devastating that a 12-year-old kid was actually killed by police officers when he was playing with a toy gun. However, the analysis in this case is sound, and the reasons are, of course, an officer can use deadly force if they fear that they are in imminent risk or someone else is in imminent risk of serious physical injury or death. Here, the officer, when he gets to the location, he observes, yes, this young boy, Tamir Rice, playing with what looked like a gun. In his mind, he doesn't know that it was a firearm. At his distance and location of where he was, he couldn't tell that it was actually a toy. So unfortunately, because of that fact that Tamir Rice was playing with a toy gun, it appeared to the officer that it was a real gun. Then unfortunately, the federal government was right in their analysis that they would not be able to prove the case beyond a reasonable doubt. Not in terms of looking, could they have presented it to a grand jury and got an indictment? They have to think about what's the long game. If you can't prove the defendant's guilt beyond a reasonable doubt, then you can't bring any charges in this case. The grand jury for that state already decided when the standard is much lower by preponderance of the evidence that there wasn't enough evidence to actually pursue charges against this officer. So it's sad. for all sides. It is sad for humanity. It is sad that a 12-year-old boy lost his life, but unfortunately, because of the law and what this officer reasonably believed, unfortunately, charges will not be charged in this case against him.
Thank you so much, Bernarda and Bob. Excellent commentary on our first 2021 series. Stay with us for regularly scheduled programming. You can find me at Bianchi ESQ.